Hello, this is Attorney Davis Younts. I'm here with Caleb Byrd, my law partner. We are the Younts Law team, and we are going to begin a series of videos today that talk about the military justice process, as well as just bring an insider's perspective to what we do in the military justice system. So today, in this video, we are going to spend some time, an hour or longer if it takes that, to really give an exhaustive look and a discussion of the court-martial process. So as we do this, we're going to go through each step in the process from investigation to actually being at trial. And we're going to try to bring it into a level where you can understand and you can engage with this video and use the comment section to ask general questions and go from there. Nothing in this video is legal advice. Please don't put confidential information in the comments. The government could get access to that, but absolutely use this as an opportunity to kind of learn and educate yourself on the process, and then reach out to us if you or someone close to you is going through a court-martial process. So with that, I want to let Caleb give kind of a brief introduction, share his bio, and we'll go from there.
Yeah, thanks, Davis. So, Caleb Byrd, I am an Auburn and Liberty graduate. I went to Auburn for undergrad, Liberty for law school. After law school, I joined the Army JAG Corps. I spent 7 years in the JAG Corps. I got an opportunity to do a lot of the really fun jobs, the sexy operational deployment, warheads on foreheads kind of gig. Then came back stateside with my family and was at Fort Bragg for 2 years, where I was a trial defense services officer. At the time I was there, Fort Bragg TDS office was the busiest in the entire Army. It typically is. So got a lot of great experience there doing criminal defense, and then became the special victims prosecutor at Fort Knox, Kentucky, where I was there for 2 years. And so after 7 years in the JAG Corps, 4 straight years of doing criminal law, I got out. I came to join you here at the law practice, and we've been rolling for the last 18 months together. And so I'm excited to kind of share some tidbits about what we see on the court-martial process and maybe some good do's and don'ts.
Awesome. Love it. So let me just kind of share my background, give you the brief highlights for me, and then we'll jump right into it. So my background is Air Force. I did 11 years in the Air Force as a JAG. I was in law school at Dickinson Law School in Pennsylvania when 9/11 happened. And so that was the moment for me where I felt like it was time for me to serve. So I did that. I was a prosecutor first in San Antonio, Texas, then at the Air Force Academy in Colorado Springs. The Air Force forced me to become a defense counsel, not something I wanted to do, but they gave me the opportunity to do that, and I never looked back. Doing that, serving the airmen, the officers at the Air Force Academy was an awesome experience, and I would have a hard time going back to the other side to be a prosecutor ever again based on that experience. So that's kind of what introduced me to the defense world. From there, I became a senior defense counsel, so I was responsible for supervising all of military defense services in South Texas and trying the felony level cases. Last job on active duty after I deployed was to serve as the chief of the military justice division at the Air Force JAG School. So I was in charge of the curriculum and developing the initial training, as well as advanced trial advocacy training for JAGs and paralegals in the Air Force. And transitioned to private practice after some time in the Guard. I did retire from the Air Force Reserves as a lieutenant colonel in December of 2022. I've had my own law firm since 2019. I actually met Caleb at Fort Bragg, now known as Fort Liberty, formerly known, and in my heart will always be Fort Bragg. We did a case together there, a very difficult, challenging sexual assault, child abuse type case that we were successful in. We were able to reveal that it was filled with false allegations by someone who was having an affair and seeking a divorce. And we got a great outcome in that case, but that was the first time we worked together. And I failed to mention I'm a Liberty grad. For undergrad. That's where I got my bachelor's degree. So Caleb and I shared that in common. We shared faith in common. So we've stayed in touch since then and had the opportunity to work together. So that's our background. That's just gives you an idea of where we're coming from. You're looking at, 3 decades of combined experience at this point when you put it all together. So we want to talk about the court-martial process. And as we go through this, I want you to kind of think of it from the perspective of an airman or a soldier that's actually going through the process. So we begin with an investigation. So what happens in the military is an individual doesn't necessarily know that they've been accused of a crime. They don't necessarily know they've been charged or they're under investigation at all until what I like to call an ambush interview happens. So Caleb, can you kind of speak to what it's like for an individual military member to find out that they are under an investigation?
Well, I mean, the way to really think about it is just imagine you're in the military, you're going through your daily normal life. You show up to work, you do PT, it's a normal day, you start your day, and then your first sergeant comes and says, "Hey, get in the car with me. We're going over to CID." And you're probably like everybody else that we've worked with, just shocked. Like, what are we going to CID for? And so you show up to CID, they stick you in a room for 45 minutes or 2 hours to put you on ice. Then an investigator comes in, he tries to be your best friend, and then, oh, by the way, you're the subject of an investigation, and we've been doing this criminal investigation on you for 6 months, and you had no idea. And so most people are completely caught off guard when they are dragged into CID without any notice, and then now they're in an interview with a CID agent who's making promises that CID can't keep and telling you, "Well, just help us out, right? Just we want to hear your side of the story. What really happened here, and we can make this go away." And so it's an extraordinarily stressful time for most people because they're completely caught off guard. They're not expecting it. It's a complete interruption to their life, and then now suddenly you're under an investigation and you don't know what to do.
Yeah. So, Caleb, you're talking about CID, the Army Criminal Investigations Division. It's the same. It's the same for whether it's the Navy or the Marine Corps, NCIS, the Coast Guard, CJIS, or the Air Force and OSI. This process is the same. It really is an ambush interview. So I want to ask you this, Caleb, for someone who's experienced that. Again, you may have been in the military for 2 years. Maybe you've been in the military for 20 years and you've had a stellar career. You've done everything Uncle Sam's ever asked you to do, never been in trouble at all. And all of a sudden you're sitting in this room, preparing for an interrogation with this, OSI CID agent. What can I ask you this from your perspective? If someone is innocent, if they did nothing wrong, why wouldn't they just cooperate with CID? And you made some comment about the agent saying, "Oh, we're just here to help you out. We want to get, your perspective so we can share that with the chain of command." Can you give us some insight? Why wouldn't we just talk? Why wouldn't we cooperate?
Well, first of all, you have a constitutional right to an attorney. You have a constitutional right to remain silent. You're never required to provide any evidence against yourself at any proceeding under the Constitution when it comes to criminal proceedings. And so the reason we don't want people giving statements is because that CID agent is never going to share with you what they have. They're never going to tell you, "Well, this is the information we have. Take an opportunity to look at our case file and then fill in the gaps for us." No, what they're trying to do is get you to make admissions. And most people think, well, if I'm just honest, then nothing bad's going to come out of this because I didn't do anything wrong. Unfortunately, every time you open your mouth and you make an admission, you are limiting your ability at trial. The way I really like to think about it is if you imagine a football field, if you come to us and you have never given a statement, we have the entire field to play with. But
Okay.
every time you give a statement, those sidelines get more and more narrow and limit what we're able to do for you in your case. You are much better off invoking your right to remain silent, invoking your right to an attorney, and allowing us to come alongside you and help you so that eventually, if you do make a statement in your case, we are making one that's direct and targeted to the needs that you have.
And so I kind of want to dive into that a little bit deeper. I think one of the things that I was just somewhat shocked to learn as a young prosecutor in the Air Force was just learning more about the training that military investigators go through. So all of the military investigative services go through what's called FLETC, the Federal Law Enforcement Training Center. They actually go through this course, and I've actually taught and done some work for FLETC, mostly when I was still on active duty dealing with the agents. But the issue is they're all taught from the same playbook. They're all taught to run investigations the same way. And the problem is they still use outdated techniques that essentially every other law enforcement entity in the United States doesn't use anymore. They use something called the read-in-baugh techniques. Now, they'll still deny that, but I've seen the training slides. And the problem with the read-in-baugh technique, which they still base their training on, is the read-in-baugh technique is designed to psychologically manipulate people into making statements and making admissions that are potentially incriminating. And inevitably what happens is, even if someone is innocent, the things that they say to law enforcement in that setting with the training that military investigators have, if they've forgotten a detail, if they don't remember something, if they're stressed and they shut down and they don't provide a detail, anything they say or don't say once they start making a statement can be turned into an allegation of obstructing justice or making a false official statement. And the problem is, military investigators, not all, there are some good investigators out there, but military investigators are typically extremely inexperienced. So what you see, just from a practical, this is real practical insider baseball here, but the reality is, it's someone, sometimes they're prior enlisted or they come in, they're commissioned, and they go into that investigator role. And what happens is they don't have practical real world experience actually doing investigations or solving crimes, fighting crimes. So they rely heavily on this idea that they are smart enough and they can use psychological manipulation in an interrogation to get admissions or a confession. And that's really what they base their investigations on. So they are taught, no matter what, believe a quote unquote victim, believe a complaining witness. In every case, they're taught to just believe them, take everything they say at face value. And then they're taught to treat the subject, the person that's suspected of a crime, the military member that's brought in, as if, you know, they should be subjected to the same kind of interrogation and psychological manipulation that has been discredited, that is shown to be, you know, poor law enforcement techniques, that's actually led to false confessions in other cases. And false confessions are a real thing that can happen. But again, they don't work for you, regardless of what they say, and they are allowed to lie. I mean, that's just shocking. They can lie to you in an interrogation. They are legally permitted to do that, and they are taught that it is morally acceptable to lie to someone. And those lies can be very small, and they can take on huge forms. But they can say things like, "We have everything on video. Everything you did was recorded. We have it on video. You're going to go to jail for a long time if you don't tell us what happened or give us your side. But if you give us your side, you know, we can put in a good word with the commander, and, you know, I think it's going to be looked on a lot more favorably." Or they'll, you know, it could be big lies like that. It could be very small lies. I mean, every interrogation I've ever watched, it seemed like every agent is always from a hometown near your hometown. They have the same favorite sports team as you do. I mean, it's like you guys dated the same girl in high school, right? Like, it's crazy the little lies they will make up just to build a rapport and go through this investigation. So just understand, when you hear attorneys say, and you hear this all the time, hey, you don't have to talk to the police, invoke your rights. In a military setting, it's absolutely critical that you do not make a statement when you're under investigation without consulting with an attorney first, because of the techniques they use, because of the military system, because of the believe the complaining witness, believe the victim mentality that they're taught. It can be a very, very dangerous thing, even if you are perfectly innocent. And the thing is, you can always cooperate in some way later. If you have an attorney involved, if you have us involved, we can interface with the JAGs, with the prosecutors. We can talk to the agent. We can get written questions. We can take steps to hire a private investigator during the course of an investigation and find exculpatory information to help. So all of that is there. But again, that initial ambush is going to be one of the most difficult, shocking, hard things that you've ever dealt with in your life if you're subjected to that. So just know you are read your rights for a reason. And it's never going to hurt you to say, I want to remain silent. I want to speak to an attorney, and you can address those things later. So that, I think, is very, very important. And that's kind of covers the ambush interview. What I want to kind of move on to and talk about is, Caleb, can you speak to, is there an advantage to having an attorney early on in an investigation, or what is your recommendation as far as when to get an attorney involved in a case?
Yeah, so this is one of the most common questions that when we're looking at potential new clients, that all new clients ask us is, well, why would I hire an attorney now and not wait till I'm actually charged with a crime? Well, what hiring an attorney does for you during the investigation phase, especially early on, is it opens lines of communication and information that you're not going to get otherwise. You know, there are numerous examples that we have of clients who are under investigation that don't know what's going on. Once we get involved, we're able to reach out to the command. We're able to reach out to the attorneys on the other side. Able to reach out to the investigators, and we can get a much better sense of what's actually going on in your case. And then we can advise you on the best way to move forward. Sometimes what that means is, hey, actually, you're not the big fish in this case. And if
Mm,
we can provide information early, you're going to be in a much better position than you would if you if you just didn't know what was going on and you just sat
mm.
back and didn't do anything. It also means that your attorneys are getting the first view of everything that's happening, and we're not having to learn your case after the fact. So having that attorney come on as early as possible is absolutely the best answer, in my opinion.
Yeah, and I mean, I can think of a couple of different, I mean, examples that we've had probably in the last 12 to 18 months since we've been working together. I had a case involving an Army chaplain stationed at Fort Bliss, and that was a situation where he reached out to me. It was under investigation. The end result of all of it is his wife, his spouse, was having an affair, and she was actually having an affair with a convicted child molester, which goes to the story. So she, because of just a lot of things, trying to gain an upper hand in divorce proceedings, custody proceedings, she created false allegations of, spousal rape, sexual assault within the marriage, as well as tried to coach their daughter into making false allegations of
Yeah.
child abuse. And when this chaplain reached out to me early on in the investigation and explained to me what was going on, he didn't know anything about the affair. He couldn't understand. To him, this was just bizarre. It was an ambush interview. Couldn't even understand why his wife would bring these allegations. And so I just asked a few questions based on my experience. And I quickly learned that his wife had moved back to Fayetteville, North Carolina, the home of Fort Bragg. And I just asked, were you stationed there before here? And he's like, yes. And I said, okay. And your wife just like disappeared in the middle of the night and moved to Fayetteville. Is that what you're telling me? And he said, yes. And I said, chaplain, I said, brother, I hate to be the one to break it to you, but I think your wife is having an affair. And he's like, no way, no way, no way. I mean, almost 20 years of marriage. Right. And, so I said, okay. I said, I could be wrong. I'm not a prophet by any means, but I'm just saying there's things about the story that you're telling me that, A leads to B. I've seen this play out before. So during the course of the investigation, we went out, hired a private investigator. The private investigator was able to learn that this spouse was having an affair with a convicted, had done time at Leavenworth, child molester. She was living with this person and, of course, lying about it, but he was able to lay all of that out, which showed the motivation for it. And so, we were not able, the prosecution in that case was unreasonable and ridiculous, even though we turned all of this exculpatory information over to them. We were able to show lies, we were able to show proof of coaching and all of that. The advantage in that case was, even though we couldn't stop it from going to court martial during the investigative phase, we had all of this information. So when we went to trial, there were 11 charges. The judge dismissed 9 out of 11 on the basis of something called a directed verdict. In other words, the judge found there wasn't enough evidence by any means on 9 of the 11 charges to even let those charges go to the jury. And then he was fully acquitted of the other 2. But the key in that case was, we had access to the information early because we were involved in the investigation. We've had multiple cases where we're able to get access to exculpatory information or other information that provides critical context, share it with the prosecutors at the appropriate time as part of negotiations or other things, and the investigation has gone away. Sometimes that may be an exculpatory polygraph, maybe other additional drug testing that's done if it's in a drug case, or the background information. So I would just kind of echo what you said. There's a lot of value added to having an experienced attorney involved in the case in that investigation stage, because you don't have to just sit back and wait another 6 months after you're called in for that ambush interview, or another year for it to get to trial. There are proactive things that we may be able to do. So that's the big picture with that. We can talk another time on another video about some other things about investigations to be on the watch out for. But I think the big takeaway from this is you don't have to provide a statement. You can and should consult with an attorney. And there is an advantage to hiring an attorney, getting an attorney involved during that investigative stage. The last piece I want to talk about, and I just want to hit on this briefly. Caleb, this is what we do for a living as civilian attorneys representing military members, but we were both military defense counsel as well as prosecutors. What's your perspective on, is there an advantage to hiring a civilian in that investigative stage? And what's different about what you might be able to bring to the table, I might be able to bring to the table than what a military counsel can provide?
Yeah, so I think there's a lot of really good military counsels out there. Obviously, this is where you and I both cut our teeth. The problem I see with military defense counsel is they're understaffed, they're undermanned, and they're overworked. And so they are constantly in triage mode. They're in and out of courtrooms every single day. So
Hmm.
what that means is they don't have the time to deal with every single investigation that comes through the door and to be proactive on that case. And so the advantage of hiring a civilian attorney is really, I can think of two very important reasons. Number one, a civilian attorney who's been doing this for a number of years has more experience than your military trial defense attorney. The reason for that is most of your trial defense attorneys now are coming right out of their basic course and into a defense job.
Hmm.
Most of them don't have a lot of prosecution experience. I know I didn't when I came in, and that's absolutely terrifying because you're trying to learn the plane as you're putting it together as it's taking off down the runway.
Hmm.
The second reason you want to hire a civilian attorney is because we are not in triage mode, right? We have a greater ability to manage our cases, our clients, and we're able to devote more time and energy to each specific client than you would get at a military with a military defense attorney. Now, at the end of the day, we love working with military defense attorneys. We have them on every single case we do. There's a lot of good things that can have with having a local military defense attorney. Uh, but for anyone who's considering, hey, should I bring on a civilian attorney onto my case? It's never going to hurt to bring in someone with a little more experience and a little more ability to manage their time and their schedule onto your case to help you prepare and move forward.
And so I want to kind of practically break that down for a second.
Yeah,
You threw out the idea of experience, but I think we can put it into a little more context. I mean, in my time in the Air Force, I was a prosecutor. I was a very busy prosecutor. I was in the busiest jurisdiction for the Air Force as a prosecutor, and later as a senior defense counsel, we had the busiest region in the world that I was responsible for. But I mean, I tried 40 court-martial
yeah,
cases as a prosecutor before I was a defense counsel. I can tell you, I don't believe, and I could be wrong about this, but I ask for these numbers whenever I talk to colleagues and former friends and things like that. I don't think there is a currently serving JAG in the Air Force that did as many court-martials as I did in my time as a prosecutor, let alone as a defense counsel. And I
yeah,
mean,
sure.
double, triple that number, right? So I've been engaged. I stopped counting after about 150. So I've been involved in trial for well over 200, maybe it's 250 court martials. I'm not sure. It's a lot. And I've been involved in, it's got to be close to 1,000 investigations at this point, doing this for
Yeah.
2 decades. When we worked, the first case we worked together, when I met you at Fort Bragg, you had no military prosecution experience. You went straight into a defense counsel job with no prior experience. How many cases had you tried that went to trial before our case together?
Zero.
Right.
I had
So,
so this is one of the crazy things. So I was 2 weeks into my job at Trial Defense Service. I had just come off a deployment. I had never been a prosecutor. 2 weeks in, my senior defense counsel walks in and goes, "Hey, I've got this really tough case for you, but don't worry. There's this attorney on the other side, Davis Younts. He's great. Just do everything he tells you to do, and you'll be fine." And I have not, at this point, I have not done a motions hearing. I have not done an Article 32. I have not been in a courtroom in a military justice system. And it was literally one of the most complex cases that I worked on at
mm,
Fort Bragg 2 weeks into the job.
right. Right. I mean, and it was one of those interesting situations where your senior defense counsel and I had worked on a murder case together, gotten a really good outcome, very complex case as well. and then we rolled right into your case. So I think that's kind of the takeaway. Again, I could give other examples. The first Marine Corps case I ever did as a civilian, it was a Marine Corps gunnery sergeant, right? Like a combat veteran, highly decorated, just an absolute hero, picture perfect Marine, all kinds of allegations against him. And he was assigned a brand new Marine Corps JAG who was fresh out of law school, barely had passed the bar, and had absolutely no experience at all. And you have a, combat decorated, legitimate hero, gunnery sergeant in the Marine Corps with someone who has not even no experience as a JAG in the courtroom, no experience as an attorney at all. And that's just the way the system works. So I think it's important to keep those things in mind and just understand that. And there are some great military counsel out there, but it is always triage mode. And as I tell people, unfortunately for military counsel, they don't get paid any more or any less, whether they work a 40-hour week or an 80-hour week. And the reality is most of the good ones are working an 80-hour work week, which is why they're in triage mode. They can't strategically think about your investigation when you haven't been charged with a crime because they're preparing for a general court martial next week. So, all right. So I want to kind of move on, and this gets a little bit, I guess, nuanced as we talk about it. So we go through this investigation. This military member's facing an investigation. The investigation is complete. What happens to it, and how do we move from an investigation to the next step in the court-martial process? Walk us through that.
Yeah, so it's important to remember, and this is a little technical, but military courts are not Article 3 courts under the Constitution. What this means is they're not a standing court. They literally do not exist until a commander orders the court martial into existence. And so to do that under the UCMJ, the commander has to, and stop me if you've heard crazy military acronyms before, but they have to prefer and then refer the case to court martial. So the first step is preferral. Preferral is the process by which the soldier, the airman, the sailor, marine is given their charge sheet and informed for the first time, this is what we are charging you and accusing you of. And so that is what kicks off the court martial process. Once that happens, there are certain rights that automatically kick in, such as a preliminary hearing, also known as an Article 32, before your case can be referred to a court martial.
So I want to just kind of stop you there and talk about this preferral process, right? Because these are words, some of them feel kind of made up when we talk about the military justice
That's
system.
because they are definitely made up. Yeah.
So unlike the civilian system where you might be arrested and brought in before a magistrate or something else, what happens in the military system is once this investigation is complete and a commander has made the decision, and we'll talk about one nuance to that in a minute, but a commander's made a decision to move forward with charges, they literally put those charges, they type those, the JAG types those charges out. Those charges are put on a charge sheet, a military document, a military form. You're brought into the commander. Usually the first sergeant is there. Some other enlisted leader is there. And you are at the position of attention and you are formally read the charges. That's what it looks like, right?
That's correct.
Okay. So after that preferral of charges, then there are two paths it can go down. One is the path towards a general court martial, which is the most serious, I think, felony level charges. That those cannot go to trial. That preferred set of charges can't go to trial until there's what's called a preliminary hearing, which is pursuant to Article 32 of the Uniform Code of Military Justice. What about the other types of court martial? And are there other types of court martial that don't have to go through that Article 32 process?
Yeah, so the other forms of court martial is a special court martial with judge alone, and then a summary court martial, which is just a court martial in name only. So a summary court martial does not even result in a conviction. The way to think about that is it's really a souped up Article 15.
Okay.
A special court martial, which does result in a conviction, that is judge alone. The max cap of confinement on those cases is only 6 months, and so it's called a short special, a judge alone special. Those are rare. The only time I've ever even done those as a prosecutor or a defense counsel is we've pled down to that for some reason. You're not
Right.
entitled to any kind of panel or jury in that case. And then there is a standard special court martial. Standard special court martial is up to a year confinement. In most
Okay.
jurisdictions, it's very similar to a misdemeanor court, as opposed to a felony court, which would be more of a general court martial. But those three, summary, judge alone, and special, those three court martial types, none of those require any kind of preliminary hearing or Article 32. You could be referred directly to those.
So can I ask you, in your experience, can you give us an example of a case that's gone to one of those three types, whether it's a summary, a judge alone special, or a special court martial?
Yeah, so generally, when we're looking at summaries and judge alone special, you're getting there by a plea deal
Mhm.
for what you would consider minor offenses, like for example, assaults, general just assault and batteries. A lot of times, those get pled down to a summary or a special with judge alone. The other big one, and we see these a lot, are special court martials. Usually, these are a special court martial is typically a first time offense, so there's no history of misconduct, and it's not a sexual assault or rape or a murder. It's not one of those bigger typical felony cases. So I've had a lot of, for example, I've had a lot of first time domestic violence cases that would get referred to a special court martial. The reason for those is typically you're not going to get a multi-year sentence unless there's some kind of aggravating factor. And so
Serious, really serious injuries, long-term pattern, things like that.
strangulations, typically those are going to go to a general court martial, but a first time domestic violence, but a bar fight that results in a assault and battery, those types of cases are generally at a special court martial.
Okay. What about, have you seen like larceny, small amount theft cases go to special court martial?
Well, it's really interesting with the larcenies, because most of the larcenies I've worked were actually there was some bigger ring of
Mm,
larcenies that was going on, and so we were talking about, hundreds of $1,000s of military equipment that
mm.
had been stolen, or as- AFES goods that had been stolen. But I
Yeah.
have seen some smaller level larcenies. If we're talking like under $500, under $1,000 total, a lot of times those just get sent over to the special court martial because they're easier to move, they're faster to move. I had a judge who one time said that his expectation for a general court martial referral to general court martial, he wanted it in about 90 to 120 days, depending on what the
Wow.
calendar was. Now that never happens, but that's always what he's
Right.
going to set his calendar for,
Right.
right? But for a special court martial, 30 to 60, like 45 to
Sure.
60 days, he wanted it on the calendar to be able to go because those are cases that the courts and the commands all want to move more quickly.
Okay. Yeah, for me, I was thinking about what I've seen. I've seen a few summary court martial cases. Again, those typically are a more serious investigation, a more serious allegation. It's pled down, or sometimes because you can go to the brig, go to military confinement for 30 days at a summary court martial. I have seen commanders when they're trying to send a message, right? They're trying
Yeah.
to isolate one person, try to make an example out of them. So they've done it for that when normally it would be handled administratively through an Article 15 non-judicial punishment or something else. For the judge alone special, I've done one. They're just so few. They're so
They're very rare.
rare. The one I did that wasn't the result of a plea or anything else was a drug case. It was an allegation of wrongful use of prescription medication. And so we didn't have a right to a traditional jury trial. But what was interesting is the military judge was a good, wise, fair, very experienced military judge, and it was still a full acquittal. So, I think that process can still be fair, even though you don't have that
Yeah.
entitlement to the court martial panel. But it's a very rare tool that's
And
used. Okay,
I'll give you
go
another
ahead.
example too with the summaries. A lot of times what
Mhm.
I see summary for is if you imagine if you've got like an E7 or E8 with a good career on the verge of retirement who pops hot for cocaine at 19 years. That's
Mm,
typically going to result in like a summary court martial. They're going to prefer
okay,
charges, they're going to plead down to a summary because this is the person they want to set an example to the rest of the force. Hey, even if you're an E7 or E8, you're not going to get away with drug abuse and misconduct. I've seen a lot of those kind of summaries, but like I
sure.
said, that's always the result of a plea.
Okay. Yeah. And I would say, I mean, percentage wise, especially when I was still on active duty in uniform, I would say percentage wise, the majority of the special court martials that I've done have involved drugs.
Yeah,
That
same.
I would say that's pretty common. Okay. So now when we talk about a general court martial, we're talking about the most serious crimes. We're talking about, homicide, murder, physical violence, large theft rings, theft of government property, sexual assault, right? That's a huge issue in the Department of Defense, how we handle those cases. So we see that, and then there's this Article 32 preliminary hearing that occurs before it can go to a general court martial. So I want to kind of break that down just so people can understand it. This is supposed to be a check, right? This is supposed to be a logic check, a fact check, a legal check in the process that says, hey, there's enough evidence to go forward to trial. So what is the standard that's applicable at that hearing? And then we'll dive into kind of your experience and how that's used.
Well, I would say the real question when it comes to an Article 32, if I can quote the great philosopher Drax the Destroyer, is not what is a 32, it's why is a 32.
Mm.
The simple fact is, an Article 32 is a really outdated procedure that still exists as part of the Uniform Code of Military Justice. Uh, in the olden days, when Davis was a young defense attorney and young prosecutor in the military, an Article 32, you could kill an entire case there. Because if you could show the preliminary hearing officer that there was not probable cause to move forward with a charge, the command could not take that charge forward to trial. Now it's very pro forma. Even, and I've seen this personally, even if uh, the preliminary hearing officer says no charges on this charge sheet meet the probable cause standard and it should not be sent to trial, the commander can completely ignore it, and the commander can refer charges and send you to a general court martial regardless of the outcome of the Article 32 hearing. And so
So so that really is wild, right? Like
that's
there's this
insane.
process, there's this process in place. It's established by law. It's part of it's part of the Uniform Code of Military Justice where we say, okay, a general court martial is so serious. There is so much at stake for the person going through this process that we're going to bring in a JAG, an independent JAG with no ties to this case, to review all of the evidence, decide whether or not they independently believe the government has met the probable cause standard.
Right.
That's their legal determination, factual and legal determination. And then to take it a step beyond that, they can make recommendations. I've been an Article 32 hearing officer before, where you make recommendations on whether or not the case should go forward to trial. So, for example, there were several cases where I was an Article 32 hearing officer where I said, hey, technically, probable cause is a low standard. Technically, the government has enough evidence to go forward under this legal standard, but practically, they should not go forward because they're not going to be successful at trial. The chances of getting a conviction in this case are really non-existent because there's credibility issues with complaining witness, or I'm surprised I wasn't fired after saying that, daring to
How dare
challenge
you?
a victim or a complaining witness in a case and bring up credibility concerns. But even if you make that recommendation, it could still go forward. I mean, I had a homicide case at Bragg that was, we even had, I mean, I did a really thorough cross-examination of an expert witness that they called, and I even had a report from our own expert that just tore apart the government's premises for murder, for homicide. And the IO saw that, made a very clear recommendation. There is not probable cause to go forward on a homicide charge, and the government did anyway. So the government is not bound. The convening authority, which is the person, the commander within the chain of command that has the authority to convene, to create this general court martial through the referral process, they are not bound by that. So that's an interesting part of this. And as Caleb hinted at this, a long time ago, before there was no gray anywhere, the government used to call, when I was a prosecutor, we would call the complaining witness in a sexual assault case. We would call the victim in other cases, and they would testify. And as a defense counsel, we would cross-examine them. And if we destroyed their credibility at that 32, there was a reasonable likelihood that maybe that case isn't going to go forward. That's changed now. Practically, the government, I mean, I'm preparing for an Article 32 for an Air Force officer at the end of the month, and the government's not going to call a single witness. All they're going to do is put in this OSI investigation, the investigation we talked about it by the investigators without experience, right?
That's right.
And that's all they're going to do. So it really is a form over function process right now, unfortunately. So I cut you off. What else did you want to say about that 32 process?
Well, I would just say that what the Article 32 is supposed to mimic is the civilian grand jury process. There's no right
Right.
to a grand jury in the military. So the Article 32 is really supposed to mimic that process. But
Okay.
Congress has taken all the teeth out of the Article 32. I think my personal record at an Article 32 was 8 minutes. And when I was a special victims prosecutor and supervising other attorneys, I used to tell them, if your Article 32 takes more than 20 minutes, you have failed at your job.
Right.
And so again, this leads to kind of the next question, which is, should you even go to the 32? I think there is some value to forcing the government to go through the steps and do an Article 32, especially if we can get on ground and meet with the client and meet with the other
Mm-hmm.
military defense attorney on the case. There can be a lot of good value to that. But for, I would say, a lot of cases, the right answer for most of our clients is probably waiving the 32, getting the discovery early, and getting really cranking on the case, moving experts, etc.
Okay. So just to kind of follow up on that, break it down a little bit. This investigator, the preliminary hearing officer who does the Article 32, they take all the evidence in, they write a report, they make recommendations, findings and recommendations. That takes time. So if you waive it and the case is referred, that speeds up the clock as far as getting to trial, getting discovery going. But the other piece of this is a question of a waiver or not. Um, from our perspective as defense attorneys, there's been cases where we've waived Article 32 hearings because we've noticed a significant problem with a charge on
Oh
the
yeah.
charge sheet. I mean, I had a case, a very, very serious case, multiple allegations and things like that. But one of the most serious charge on the charge sheet from the government was a crime that carried the possibility of life, right? Life in Leavenworth. But the government, in addition to just being wrong about the way they charged the case and wrong about the allegations in the first place, they didn't do their due diligence and they were outside of the statute of limitations. At the
Right.
time, that allegation had a 5-year statute of limitations. They didn't bring charges until a couple of months after the expiration of that statute of limitations. So that does not exist. Legally, that court martial has no jurisdiction over it. And so in that case, we waived the Article 32 hearing because we were afraid that an experienced JAG working as a preliminary hearing officer would realize that was an issue and make a recommendation to the government to change that charge, because the IO can do that. They can recommend things to the government to improve their case, like changing charges and curing a defect is what we would call it on the charge sheet. And so they could have changed that to another crime that was just as serious, but wasn't what they had charged, that would expand or change the statute of limitations. So there are absolutely strategic reasons where the defense team may decide it's appropriate to waive that Article 32 hearing. And that's one of the things we talk through with clients. I mean, we all show up for this hearing and it may last 8 minutes. It may be
Right.
just the government literally handing the IO an investigation, the hearing's closed, and we move on. So that's just, hopefully that kind of demystifies that stage of the process. You may have more questions than answers based on what we've said. That's fine. Ask them in the comments, let us know, and we can talk through that. But okay, so we've used this term and we've talked about how a military court doesn't exist until it's created. It's not an Article 3 court, so it has to be created in order for it to occur. So once the Article 32 is complete, the case is referred by the appropriate commander, the General Court Martial Convening Authority. And then once that case is referred, when is a judge first assigned in a court martial? When is the first time we might have access to a judge?
So that's going to be a referral.
Okay.
As soon as the court is ordered, referred to a court martial, a judge is going to be assigned to your case. And
Okay.
then typically, once a judge is assigned, there's going to be an arraignment. Most arraignments now happen probably within the first 2 weeks. It's usually virtual at this point. But that arraignment takes place as quickly as the judge can get it on the calendar.
So there's slight nuances between the way the services do this piece of it. But I think the big takeaway is once referral has happened and we know this is going to a court martial, then a judge is assigned. The judge will hold a docketing conference. So the judge will lay out, okay, here's when we think we're going to go to trial, and we'll set a schedule, some type of a pretrial order that outlines this is when discovery is supposed to happen. This is when expert requests are supposed to happen. This is when motions hearing are going to happen. And then arraignment. And arraignment is kind of a funny thing because the Air Force typically does it different than the Army. And there's nuances in the other service, and sometimes it's jurisdictional. So the Army typically arraigns people as quickly as possible. What is an arraignment? An arraignment is an archaic, almost pointless, but not entirely pointless legal proceeding that I tell people goes all the way back to England, when most defendants could not read. And so an arraignment is supposed to be where a defendant goes into the courtroom for the first time, they stand before the judge, and the judge reads them the charges so they know specifically what they're being charged with. That's the history of arraignments. Anybody in the military now, in order to pass the ASVAB, you have to be able to read. At least that's the theory, right?
Supposedly.
And so you know what the charges are. So legally, though, there are certain motions that have to be filed or discussed prior to arraignment, or they can be waived. So legally, there's a huge significance to arraignment. It also stops, at least practically, the speedy trial clock, meaning the government can move slower after that technically. So it buys them time because they only have a certain period of time to bring the case to trial. So an arraignment is one of those things. Again, it's that terminology you're going to hear. It has legal significance. Practical significance is small, except when it comes to motions. So now, kind of move through that quickly, not to get bogged down in it, but I want to talk about the pretrial process from there. So we've moved through, we're going to court, we know the date, we have a judge, we have this arraignment process. Where do experts fit in, and how does that fit into the military process?
So for you and me, I want experts when the case is preferred, but
Okay.
we're not entitled to experts until there has been a referral. And then typically the judge in his pretrial order will give us guidance about all expert requests need to be submitted by a certain date and responded to by a certain date. And this becomes really important for us because, frankly, one of the great things about practicing in the military system is the government has to pay for the defendant's experts. Uh, Civilian jurisdictions really don't operate this way typically. And so we get access to a lot more experts than your typical civilian would get access to. And frankly, I think it's a phenomenal thing because what it does is it helps educate and prepare us for trial on what can be very nuanced, very scientific aspects of the law. And so we see a lot of experts. I mean, I don't know of a single case we would take today where we don't at least ask for a digital forensic examiner, because there's going to be cell phones and computers and apps and watches involved, and having someone there who's an expert on digital forensics is typically huge for us. Forensic psychologists we work with on almost every case as well, because a lot of military members have depression, PTSD, and anxiety, and we need to know how that affects their case and how that's going to play out. So, experts are a huge, important part of trial for us. It's something we rely on heavily. We ask for in almost every single case, and so we want to get those experts as early as possible. So we'll always go by the court's guidance, but if I can get them earlier, I'm going to fight to try to get them on the case earlier.
Yeah, and I think that's so critical. And again, it depends on the type of case. Almost every case now has some sort of phone-based digital evidence that's a factor, and there's a whole lot of things that could be. I mean, even just geographic tracking through Google or otherwise can bring all this information in. So we have very specific digital forensic examiners that we like to work with. They're civilians, but we can request them. And if we demonstrate to the court that there's a legitimate need for it, then Uncle Sam pays for it, which is a tremendous value to military members. So if it's a sexual assault case and we need a sexual assault forensic examiner, or we need a forensic psychologist, or we need a pathologist in a murder case, the government's going to pay for that. The military member, the individual military member, doesn't have to pay for that. And that's not necessarily the case in the civilian world. I mean, I had a homicide case in Pennsylvania where the defendant they weren't indigent, so they had to pay for a very expensive, forensic pathologist to fight a homicide charge. and it was worth every dime, but it was a significant investment
Yeah.
for them along with legal fees. We don't have that problem in the military. So I think that's critical. And I think having really, really good experts that are familiar with the court martial process, they're familiar with the DoD system, but they're outside of it. So they're not just uniform wearing military members, is critical. You and I have seen that as so critical in many of our cases. That's an important part of the process. So talk to me about motions, just in general, and then we can talk about maybe some specific motions that we might see. How does motions practice work throughout this?
So the best way I know how to explain it is how a judge taught me motions, which is motions is your opportunity to shape the battlefield for
Mm,
trial. And so if you think about a judge, he receives this, all he receives is a charge sheet. So he knows the name of the defendant, he knows what the allegations are. This judge doesn't know anything else about the case. He is not
mm.
reviewing evidence. He's not looking at investigations. He's not hearing from witnesses at this point. And so, what we want to be able to do with motions is strategically put before the judge what we want the judge to know and how that's going to shape and inform the way we prepare for trial. Motions to me are a very critical piece, and it's because it's our first opportunity to really start defining what the trial is going to be about. Now we see a lot of motions. I would say we're filing motions in every case, almost every single case. We're going to have some motions. This is very, very true when it involves cases like sex assault or rape, because there are limitations in the rules of evidence that we have to get around. And so we're filing those motions early to know this evidence is going to come in, or we can use this evidence in specific ways, or we're not going to get it in at all. It's also huge for going ahead and getting certain pieces of evidence pre-admitted, pre-approved for admission at trial, so that we're not having to do this on, so we can have all of our fights and our battles away from the jury before the trial even begins.
Okay, so motions practice within the military, typically the judge has set the order and the judge decides motions before you get to trial. So we know what to anticipate. And then we can build motions, not only which motions we file, when we file them, but just motions practice in general then helps frame trial, big picture trial strategy. So examples of motions, I've done, it might be what we call a motion in limine. That is to limit evidence. In other words, we want the judge to rule before trial that there's certain evidence that is not going to come in. It's not relevant, or for some other reason it's not coming in. It may be a suppression motion where the government has done something illegal to obtain evidence without a search authorization, or a coerced confession or something else. So we might see those. I know I've dealt with those, and there can be other nuanced evidentiary motions. But the whole idea is those are done in writing. Well, for some of them, we'll get a hearing in front of the judge to argue it. All of that happens before trial, but it really does strategically shape the battlefield. Sometimes we have to file motions to produce evidence, but that's all part of it. So we have moved from pre-furl, so we know what the charges are. After the investigation, we've had the preliminary hearing, we've had referral, we have a judge, we have a scheduling order, we've gotten our experts lined up, we have motions, so we've shaped the battlefield. But how do we know? How does the discovery process work in the military? And based on your experience, kind of what are your thoughts about key points or key aspects of that?
So the military has what's called an open discovery process. Now,
Mm.
what this means is that I get everything that the prosecutor has. And so what that literally means for me is I can say, awesome, I'm going to go to CID. I want to see all the evidence that they've collected, and I want to see their notes that they took during interviews, that
I
they
love
took
that
during
point.
not only during interviews, but as they're reviewing the case and they're preparing the case and what their to-do lists are. We call those left side notes because CID, NCIS, they typically keep on the left side of their case file. Um,
Right.
Investigators absolutely hate this because it means I get to come in and second guess them and look over their shoulder as they're doing their homework. But because of the open process in the military, um, this is of vital importance to us because it makes sure that we're getting all the evidence. For example, in civilian cases, the government's going to turn over some evidence, and the government has to turn over exculpatory evidence. But there's typically more limits in civilian jurisdictions. In the military, it's an open discovery process. I get more access to not only evidence, but also to witnesses, which is something that's unique to military trials. So under the UCMJ, defense and the prosecution have equal access to both evidence and witnesses. Having that equal access to the witness means that if we want to interview the alleged victim on a case before going to trial, I can have the judge order her to meet with us and order her to give a statement to us and order her to answer our questions. That doesn't happen in the civilian world. Usually, in the civilian world, the first time you hear from a victim is when she's on the stand. Now, there could be strategic reasons why we do or do not want to do that. However, that is a unique thing that the military courts allow us to do is equal opportunity to evidence, to witness with an open discovery process. And it really puts a lot of tools in our tool bag to be able to prepare for trial.
Yeah, and there's over time, if you're someone who follows military justice, follows things like this within the military, there's different criticisms of the military process. There's always questions about fairness and other things, but this open discovery, equal access provision in the Uniform Code of Military Justice really is enforced by judges, in my experience.
Mhm.
So it's a fantastic opportunity to get access to information. And the thing you and I have experienced is we have both had multiple cases as defense attorneys where we have outworked the government and we have outworked the government in terms of knowing what's in the investigation file, as well as actually doing meaningful interviews of victims. So let me just kind of really practically explain that. As a defense attorney in the military system, we will physically go to CID, OSI, NCIS, CJIS. We'll go to the investigator's office. We meet with the investigator. We get to interview the investigator, and we literally get access to the file, and we can make copies of whatever is in that investigative file. That's the open equal access process. So we can literally go in there and make those copies, or even have a defense investigator go with us, talk to the investigator, talk to the agent, and make those copies with us. That really, really matters because we will often find things in there that we know are significant. You mentioned the notes, the interview notes. So there might be a recording of the interview. Often there is now a video and audio recording, but sometimes things aren't clear. But other times there won't be, just because of other things that are going on. And there will be things that the agent writes in their notes. And I have used agent notes to actually impeach and show a witness is lying and has changed their story on the stand, the same way we might use audio or video. And so, sometimes that's in cursive, sometimes that's messy. So you literally have to make copies of it and spend hours going through it line by line, page by page, to pull out those little things that can be significant. I had a case at Shepherd Air Force Base in Wichita Falls in 2024, sex assault case, very serious case. But one of the things that happened was there was email traffic between the OSI investigator and the DNA lab. So for the military, that's the U.S. Army Criminal Investigation Lab in Georgia. They call it UCSIL. And there was emails between the agent and the lab. And to just, make a long story short, the lab was asking for more things to test for DNA, because the lab got the expert forensic DNA examiner at the lab, got the write-up, got the report of the allegations from the complaining witness. And it didn't make sense to them, number one. But number two, they wanted access to clothing that would have DNA evidence if the story was true. And so they were asking, hey, you sent us, a shirt, but you didn't send us other things like undergarments. You didn't send us other pieces of things that we could test. Where are those? And there was this email traffic between the agent and the lab. And in that, the agent noted that they had asked for those things from the complaining witness, and she had specifically refused to provide them. And that was an off the record conversation the agent had with the complaining witness. It wasn't part of the video recording because it was just seen as administrative. It was kind of like a follow-up thing. And the prosecutors didn't read the file the way we did. They didn't go through those emails the way we did. They didn't go through them with a DNA expert like we did. So we knew that was there. And the complaining witness took the stand and lied. And I asked her, did you turn over all of your clothes to OSI? No. You didn't turn all of your clothes to OSI? No, they never asked for them. That was a lie. She refused to turn them over. She was specifically asked, it was documented that she was asked, she refused to turn them over. She lied about that because she knew the whole thing was a lie, and she knew that that would have been exculpatory evidence. So we were able to say, look, not only did she lie, but the government didn't get this exculpatory evidence that the DNA examiner wanted, and they still want you to convict our client of this heinous crime. So that's just an example of, number one, how important the open discovery process is, but also why it matters that you go through things like that pre-trial in detail, because so much work is done before you get to trial. As far as witness interviews go, the one comment I'll add to that is, military prosecutors, and we both were them, but younger prosecutors and sometimes prosecutors, whether they get busy or for whatever reason, sometimes don't go past the four corners of what's in a statement that a witness has provided to OSI or CID. The problem with that is, we talked about the investigative techniques they use. Look, these military investigators are not looking for exculpatory information. They never are. And they're not asking questions that might be exculpatory, meaning they might prove the innocence of our client. And so when we interview witnesses, we actually want good stuff, not just stuff that makes our client look guilty. And so sometimes that pretrial witness interview process can provide us information the government has no idea about, because they didn't bother to ask any real questions. And they only just, from a perspective of confirmation bias, believe the complaining witness no matter what, ignore evidence that might be exculpatory, don't think that this person has any potential of being innocent, ignore all of that. And so that's all of that process. And, you hinted at the scale of that process. It might be 60 days, it might be 90 days, it might be 6 months that we had to prepare for trial, but that's all part of it. So it's all building to this moment where we are scheduled to show up at the courthouse, pick a jury, a court-martial panel, and begin trial. So I want to talk just really quickly about how does jury selection work? Meaning, how do we get a potential people identified to sit as members of a court-martial panel?
Yeah, so that's going to start with the government has to put together, as part of the convening order, they have to actually put together a panel list. And this is the panel that has been selected by the commanding general. And some of this is changing when it comes to military justice, but it's a selection of these um, qualified officers and senior enlisted persons who can sit on panels. And usually there may be 2 or 3 panels per command that kind of rotate throughout the year. So generally speaking, what is supposed to happen is the government puts this panel together. They send the panel questionnaires, and then as part of the trial process, you and I get copies of all the questionnaires that the panel has filled out. Now, the way this is supposed to work, go ahead.
So, well, I just want to drill down on a couple of things. So, civilian system, different jurisdictions do it differently, but essentially, anyone who lives there is potentially could be called up for jury duty. So, right, you
Yeah.
live and you vote in an area, you can get the phone call. I've been called up for jury duty. Here, you can get the phone call, and you're supposed to show up at the courthouse, and there might be 500 people, and all of that. For the military, the pool is qualified officers and enlisted members that are serving in that military organization, right? So that's your potential pool. And then the same commander that decided this goes forward to trial, is the one that picks who sits.
Generally speaking, that's correct.
Okay. And so we get access to these questionnaires. So we get names and we get background about these individuals, and what happens from there.
So what happens from there is we get an opportunity to review the names and background. Uh, we're supposed to get this early so that we can identify, hey, this person is obviously biased. They're not going to be on the panel. So that when we get to the day of and we get to panel selection, one of the things that the government does not want to see happen is what we call busting the panel. And this happens really very regularly in the military. Like you were saying, if you're a civilian, you get the letter in the mail that says show up for jury duty this date. You show up for jury duty. There's 500 people. You sit there all day as they select a jury from top to bottom. For the military, for a general court martial, you're going to have 8 panel members who sit on your general court martial. Usually, there's only 14 that show up at the beginning of the day to go through voir dire and selection. And so you have to start with 8, right? So you can only lose 6 people if you have 14. Well, if the government has not done a good enough job of vetting the people who are going to sit on the panel, reviewing their questionnaires, which they're never going to do prior to trial, um, it's very easy to bust panel members, particularly in sexual assault and domestic violence cases, where what we see very often is a panel member goes, "Oh, me or someone I know that I'm close with was sexually assaulted or was a victim of domestic violence." Those people are never going to sit on a panel because you can remove panel members for either actual or implied bias. Actual bias meaning they actually think that the defendant is an evil person,
Right.
or they will never rule against someone who's accused, or they will never rule for someone who's accused of certain crimes. That's actual bias. Or
Mhm.
implied bias, that there's sufficient facts against you that there is an implicit bias that you have that you cannot sit and be an objective member of a jury. And
Okay.
so when we're going through the selection process, what you and I are trying to do is, one, get to know the panel, because this is our first opportunity to actually introduce ourselves to the panel. This is very important for us because we're not going to be in a military uniform. So the panel needs to know a little bit more about us. They can't just look at our sleeve and know who we are and things we've accomplished, those kind of things. And the second reason is we want to make sure that we're getting a panel that's impartial, that's unbiased, that is going to review all the evidence without any kind of pre precondition presumption
Okay.
against our client.
So practically speaking, then again, just picturing this, trying to paint a picture for people, we show up to the military courtroom, the prosecutors are there, the defense team is there, the judge is there, and after some preliminary stuff happens, all the motions issues are resolved and all of that, then these typically is 14 people, they come into the courtroom and the judge asks preliminary questions, then the government asks questions, we get to ask questions, the panel members are put under oath, sworn, they swear an oath to tell the truth. And it's based on those questions that we identify either actual bias, implied bias, and then we get a preemptory challenge, meaning one challenge where we can just challenge a court martial member because we have a reason we believe they shouldn't sit as part of the panel, but it might not rise to the level of actual bias or implied bias, or we might have asked the judge to excuse that person and they disagreed, which I had happen in a case at Fort Bragg. It was a sexual assault case. I think it's the only two sexual assault cases that I've done that have resulted in convictions for sexual assault were overturned on appeal. This was one of them. And this one was a situation where there was a panel member who we objected to because her daughter had gone through essentially exactly what the allegations in our case were. And there were other problematic jurors on that case. It was a terrible panel for us. We tried to challenge multiple members, and this was one that we challenged for actual bias. We challenged for implied bias. The judge disagreed. That panel member sat on the panel despite that clear bias. And I mean, she even expressed in the courtroom that she didn't think she could be fair, but the judge wanted to get the case done. He was afraid they would bust quorum, have to go chase down the general, wherever the general might be, and get a new panel, which can take a whole day or two, and it puts everything on hold. So, for whatever reason, the judge, wanted to get this done, didn't want to bust quorum, so he kept this panel member. And later the case was overturned on appeal, and conviction was overturned and dismissed because this panel member shouldn't have sat. So for general court martial, the number, unless it's a murder case, certain types of homicide cases, the number is 8 court martial panel members. And then for a special court martial, it's now 4, right? It's a set number of 4. In the military system, can you tell folks, does it have to be, what is the breakdown? Does it have to be unanimous for a conviction?
No, it does not have to be unanimous. And so, this is one of the things that we've complained about and stomped our foot about for a while. Um, the Supreme Court in the last couple of years ruled that all civilians tried in the United States are entitled to a unanimous jury. So everyone has to agree that you are guilty of what you are accused of. That does not exist in the military. So a military panel uh, does not have to be unanimous to convict you. And usually it's even hard to know in the military whether you got a unanimous panel or not.
And we'll talk about that. Remind me, I want to come back to that. So in the federal system, in the state court system, 12 jurors, and they have to be unanimous. So it has to be 12-0 voting for guilty or 12-0 voting for not guilty. And if they don't come to an agreement, then it's what's called a hung jury. And the case could be brought all over again, or the case could be dismissed. And so you hear about that. We don't have hung juries in the military because it doesn't have to be unanimous. So it has to be that 2/3. It's a 2/3 majority standard in most cases. And it really, now that we have set panels. So for most of my career, all of my active duty career, it wasn't a set number. It was just minimum. So it had to be a minimum of 3 for a special court martial. It had to be a minimum of 5 for a general court martial. So we were always looking at the numbers because certain numbers were advantageous to the defense or not based on that. But now so to get a conviction, the government in a special court martial has to get 3 out of 4. And then for a general court martial, they have to get 6 out of 8. That's accurate, right?
That's right. Yeah.
Okay. So one thing you brought up as well is, so you watch a TV show in the movies, and this does happen after a civilian trial, a state court or a federal trial. If it's an acquittal or a conviction, either one of the attorneys. So if it's an acquittal, the government will stand up and ask, we want to question the panel. And so the judge will literally say, and in Pennsylvania, they do it somewhat archaically, but they'll literally say, juror number 1, what say you? Right. So they'll announce the verdict, and then the prosecutor can say, well, I'm shocked that this, case resulted in an acquittal. I want to question the panel members. So they'll literally go down the line. Juror number 1, what say you? Not guilty. Juror number 2, not guilty. And the judge will do that. So it's on the record. And so their vote then is not private, right? In the military, what's fascinating is one of the ways that we deal with this idea that technically the commander can pick the potential court-martial panel. And there's always the problem or concern of unlawful command influence within the military system. The individual vote of a military member in a court-martial is a secret. They vote in the back. They're instructed by the judge to vote by secret written ballot, number 1. And number 2, they are ordered under the law, they are ordered by the judge not to disclose how they voted or how anyone else voted in that room. So what's fascinating about that is you literally have a scenario, and I think it's a good part. I mean, again, we should have unanimous verdicts, but because we do have this idea where no one knows, the commander doesn't know who voted guilty or who voted not guilty. They just know the outcome. So I think that is a positive part about the whole military jury selection process, that these military members know someone would have to break the law and could be prosecuted themselves in order to disclose how they voted in a given case. And so there is that freedom to do what they believe is the right thing, because they write their vote on a secret ballot, they turn it into the president of the panel, and it's announced, and nobody knows what the number is other than there was enough votes for guilty or there wasn't, and that's the outcome. So we have covered a lot of territory. We've been going on for over an hour, but I just want to hit the highlights of a couple other pieces of the court-martial process. And there's, again, 2 sides of this. One is just making sure people understand how a trial unfolds. The other piece is just a little bit of commentary from us on kind of the how and why we do what we do with each part of it. So we're in trial. We've picked a jury. It's time for the case to begin. The first thing that happens is the opening statement. So I would like, as a former Army prosecutor, senior prosecutor, I'd like you to address what is it you were trying to do in an opening statement, or what is it typically that the prosecution is trying to do in that opening statement, where they stand up and get to address a court-martial panel that really knows nothing about the case for the first time.
So in my opinion, I think that opening is probably the most important part of trial, because it's the first time that the jury is really hearing the story and what facts you anticipate are going to come out at trial. And so this is really the moment where you're introducing the panel to the trial itself. And so as a prosecutor, my philosophy was always best story wins. I want to present a story to the panel that the panel can understand, that feels intuitive, and that best explains all the potential facts and circumstances in my case. And so, from a prosecutor's perspective, I want to tell the best story in the most persuasive way possible so that I can start getting the panel to understand my case as I'm going to present it to them throughout trial.
Okay. So as a prosecutor, then you're thinking in terms of, I have the burden of proof. I have to
Yeah.
convince them that this person, the judges just told them this person is to be presumed innocent. I need to walk them through what happened. I need to preview what they're going to hear from witnesses, what they're going to see as evidence in such a way that it creates a compelling and convincing picture, so that later in closing argument, I can ask them to convict this individual. And you said a story. So you're trying to outline, this is what happened. This is the key players involved. This is what you need to pay attention to. So effective opening from a government tells a clear, coherent, cohesive story. And you and I, we've joked about this before. We joke about this a lot. What it is not, an effective opening from the government is not someone standing up and saying, this is a story about, or this is a case about, right? And
She
then,
said,
yeah.
yeah.
So that's horrible. There are ways to do it, and you don't have to be, it was a dark and stormy night on, Fort Campbell when, the heinous predator, crept through the bushes or whatever. It doesn't have to be like that, but it should be directed there. So government gives their opening statement. The defense can either open at the beginning of the case or they can wait until after the government has presented their case to give an opening statement. I have never done that. I have never deferred opening. I have heard of cases where it's been done. I have colleagues that have done it. I don't agree. And the reason I don't is confirmation bias set in during opening statement. And if the prosecutor is effective and they're doing their job well, there are court-martial panel members that might be almost ready to make up their mind just by opening statement before anybody has heard a single witness, seen a single piece of evidence, despite what the judge says about anything. That's just how people do it. The American Bar Association actually did a study that said 80% of jurors admitted that they tended to make up their mind during opening statement. That's why Caleb said it's so important. So from a defense perspective, when it comes to what we're trying to do in an opening statement, it's different.
Totally different.
I think it's vastly different. And, my take on this is not necessarily the textbook, law school answer or what, most people wanted to teach when I was at the JAG school. The goal of an opening statement for me is really to get the court-martial panel members thinking about not the story that government just told, except to get them to recognize it's just a story, because they don't know if it's true. And it's dependent on all of these factors to be true. So all I want them to do is step away from confirmation bias, to follow the law, and just have an open mind that, wait a minute, just because someone says they were sexually assaulted does not make it true. And it certainly doesn't make it true beyond a reasonable doubt. So just because there is a story, just because there is a statement, that doesn't make it true, because guess what? Sometimes people lie about sex, and we know that, but sometimes I feel like we forget it when we walk into a courtroom, right? So our job then as the defense is to really walk the court-martial panel members through a process where we say, don't make up your mind now, because it's dangerous. And that's a danger that we face when we walk into the courtroom. And so we have to begin asking ourselves, you have to begin asking yourself now, what questions do you have about the government's case that should be answered in order for them to meet their burden of proof? What evidence are they going to put forward? What DNA evidence? What forensic evidence? What digital evidence? If this story that they're telling is true, what also must be true in order for them to actually prove their case? So that's what you're doing. And, sometimes we even, one of my prosecutor buddies once said, "Oh, you really wrapped yourself in the flag in that one, didn't you?" But what that means is we will say, listen, we have a constitution for a reason. Our founding fathers understood that the law and the way the Constitution works, due process, gives you tools as court-martial panel members to make sure you don't convict an innocent person. So the burden of proof, that being on the government, the presumption of innocence, the high standard of proof beyond a reasonable doubt. Those are all things that come in. The other thing I will say about opening statement is everything that happens, everything we're doing as a defense in the courtroom, we are trying to build credibility with the panel members. And what I mean by that is we want to be organized. We want to be buttoned up. We want everything to be tight. There should be no surprises because of this witness interview and discovery process. So we should be so over prepared that nothing is shocking to us that happens, other than sometimes people lie, that we're surprised, lie, right? The first time an investigator, a police officer, an OSI agent, and I'll still remember where I was when this happened as a defense counsel, sometimes they'll lie. And, it's kind of like finding out Santa Claus isn't real. And you realize, wow, law enforcement officers, maybe they think they're right, doing the right thing for some reason, but wow, I now have to impeach this investigator that I worked with a year ago as a prosecutor because he just, perjured himself on the stand. And now I'm going to go and impeach him. So from opening statement, the government begins to present their case and they begin to call witnesses, and they'll have a strategy behind who they call and what order they call them in, and they'll be able to present evidence. So witness testimony takes two forms. You have direct examination and cross-examination. So government calls a witness. They do what's called direct examination. Give us, what is that? Why do we use direct examination as terminology?
Yeah, so direct examination is where the witness gets an opportunity to tell their version of events. Uh, Generally, prosecutors get a lot of experience with direct examination and get absolutely no experience with cross examination. And defense gets the opposite experience. We build our entire case through cross. And so we don't do a whole lot of direct examination. And so direct examination is really just the prosecutor asking the witness, okay, tell us what happened and then what happened. And well, can you explain how this happened? Right. And so that is where the majority of the case is actually put on. It's where the witness has an opportunity to tell their version of events and what they experienced and what happened according to them.
Okay. So then contrast that with cross-examination. So the government's called a witness, maybe it's the complaining witness, the so-called victim in a case, or an investigator. They've gotten their story out through direct examination, asking open-ended questions. Where were you? What day was it? What time of day was it? What happened? We then, as the defense, have an opportunity to cross-examine those witnesses. So what does cross-examination look like? How is it different?
So cross-examination is really a good cross-examination is the witness is only agreeing to what the attorney is saying. So it's really the spotlight is on the attorney during the cross-examination, not on the witness. It's asking closed questions such as, "You're wearing a green shirt today. Is that correct?
Mm.
There are books behind you, correct?" Right? And it's
Right.
really the process, it's really the attorney's opportunity to pick apart the witness's statement in a controlled way. And as far as I'm concerned, I think cross-examination may be the greatest invention in all of human history. Uh,
Mm.
because there's a lot of stories that really sound plausible and really
Mm.
sound good until a competent person stands up and asks you very nitpicking questions about
Right.
what you saw and what you heard and what you experienced it, and starts to demonstrate through cross-examination why your story does not make sense.
Right. So cross-examination is, we have a Sixth Amendment right to confront the witnesses against them, right? The Supreme Court, there's a constitutional right to confront witnesses against you. You cannot be convicted of a crime in a military court or any other court in the United States unless you have an opportunity to confront the witness against you. It's this sacred right, if you will, that we built into our system, because our system, we call it trial. It is an homage to trial by combat, right? Like that's part of where this comes from. So we have an adversarial system. So our founding fathers, and there's some, relevance to English common law, but the idea is you have two sides to this thing. You have attorneys come in, and attorneys engage in a trial by combat, presenting their best case. And it's an adversarial system. And then, the outcome is based on the panel deciding which side has won the trial by combat. Now, that's a way oversimplification, but that's the idea. But a critical part of that adversarial process is this idea that the attorney gets to question, to cross-examine a witness. Now, it is not like, or let's just say it's extremely rare that it is anything like what you see on TV or in the movies when it comes to cross-examination. Most attorneys, quite frankly, are not very good at cross-examination. Most attorneys are intimidated by cross-examination, and they either do too little, or more common mistake is they do too much. They ask questions they don't know the answer to, or they say, so, and then they ask another question trying to get the witness to agree with the conclusion that they've reached, rather than simply letting it go and arguing that conclusion based on the facts later. So that's all poor. So when I prepare a cross-examination, what the way I look at it, there's a couple things I look at. You said it well, Caleb. I'm not really asking a question. I'm just making a statement.
That's right.
And then I'm waiting for the witness to respond. So I will intentionally, at times during cross-examination, I will say to the witness, okay, that night you were wearing a red polo sweater. And I'll just stop.
Yeah.
And I won't even say, is that right? Is that correct? I'll just say, that night you were wearing a red polo sweater. And I'll just wait. I made a factual statement, and I'm waiting for the witness to agree with me or not. And I'm not even raising my voice at the end like I'm asking were you wearing a red polo sweater? No, I'm just making a factual statement when it's critical to my case, especially if I think the witness doesn't want to provide that information and they're a little bit hesitant. I won't even form it as a question. I'll literally make a statement and wait for them to agree or disagree. The other thing I will say about a good cross-examination, a good cross-examination is short. It's very pointed, but it really is. I call it like you're writing a choose your own adventure book, and the witness gets to decide at some points which adventure they want to go on with you, but you know the outcome because you wrote the book, right?
That's right.
So the witness may decide to tell the truth, and that leads you down one series of questions and one path, or they might decide to lie. And it's their choice. It's just either they're going to perjure themselves, they're going to lie, and you're going to impeach them and confront them with that, or they're going to tell the truth and they're going to have to admit to things they don't want to admit to that are beneficial to your case. So regardless of whether I ask a simple question, and if the witness is willing to lie about it and not agree with that statement, then I'm going to have something. I'm going to have video. I'm going to have a text message. I'm going to have a piece of clothing. I'm going to have testimony of another witness where I've set up, okay, they've chosen that adventure. Now we're going to have to demonstrate that they lied. But it is not like what you see in the movies. It's not like TV. It's not like A Few Good Men. An attorney that's yelling and screaming at a witness on cross-examination might think they're putting on a good show. The client might be impressed about how, trickster they were, or how angry they were, or how much of a bulldog they were. And, their client will be shaking hands with the attorney as the client's led off to jail after that cross-examination. And I've seen that. Oh man, he really fought for me, and now I'm going to jail. Because it wasn't effective cross because the attorney, was a jerk and didn't prove any points by just yelling and getting upset, sometimes you've heard me say this, sometimes I just call it a disappointed father cross-examination. Sometimes my best cross-examinations are, I treat the witness kind of like a child that I know is lying. They have lied. They've been caught with their hand in the cookie jar. And now they're forcing me reluctantly to walk through and explain to everyone in the room that they're a liar and demonstrate that. And when you do it that way, I think it's much more effective. And really, it's the witness that's done it to themselves. You're not the jerk in that process. You don't have to be the jerk in that process. It's just, hey, we're just going after the truth here. And if you're going to lie to me, then I'm going to have to get out your prior statement, and I'm going to have to confront you with what's actually on, in the text message or otherwise, to walk through that. So,
well, and let me just say, when it comes to cross-examination, if I think opening is the most important part of trial, cross-examination is my personal favorite. And the mentality I've always taken to cross is, first of all, for me, I don't get away with, in front of a jury or in front of a judge, being loud and aggressive. What works for me is Southern gentleman, right?
Right.
And the reason that works for me is because it allows me to really give the witness an option, right? This can be very professional and very courteous if you answer my question and you're honest and truthful. And that's going to mean sometimes admitting to things you don't want to, and that's fine. If you're honest and truthful, I will be the Southern gentleman. But if you're going to lie and you're going to fight me, I'm going to hit you over the head with a club and drag you around the courtroom with
Right.
a
Right.
cross
Right.
examination. and
Right.
this for me is why cross examination is really the most fun part of trial, because it's one of the few places in a trial where the defense attorney is in full control of everything that is happening.
Yes. If you're
And
doing it right,
if you're doing it
you wrote
right,
the book, you know where you're going. Yeah. And I would agree with that. I mean, sometimes I've done very aggressive cross examinations when the witness is obviously lying. They've gotten snarky with me, or, it's an experienced investigator or even an expert witness that's just not being honest, that's hiding the truth, that's clearly biased. And so sometimes you go hard at those people, but it's not, it's rarely did you order the code red
that's
screaming, right?
right.
That it doesn't happen that way. Sometimes it does, a little bit that way. But not typically for the defense. So as we walk through the trial, so we picked a jury, we had opening statements, the government's put on their case, they've done direct examination of their witnesses, we've cross-examined their witnesses, then they rest their case, and then we have the opportunity as a defense to present evidence and call witnesses. Often the defense doesn't call very many witnesses or doesn't present that much evidence for a whole lot of reasons, most commonly because the government has the burden of proof. And if they haven't done their job, if they haven't met their burden of proof because they can't, because the allegations are not true, then it's you can quote Napoleon, you could quote a lot of people, but if your enemy insists on defeating themselves,
Don't
let
stop
them,
them.
right? Don't interrupt them in the middle of making a mistake. So if they haven't proven their case, if you've done a good job on cross-examination, you may not have to put on much of a case. Sometimes you will, and if you do, sometimes it's an expert witness or otherwise. Occasionally our clients will testify. I think my clients, I mean, if you look statistically, I would say my clients probably have testified more than most attorneys'
Yeah, mine
clients,
too.
and there's reasons for that. That Caleb and I have an approach to it. One of them is, if our client's truly innocent, they don't have anything to hide, and they don't have other misconduct. They haven't made statements during the investigation. They haven't messed up during the investigation, so they can now tell their story and not get cross-examined about details that they did or didn't include in their initial statement. Even if they didn't lie, they just left out, one tiny little detail that a prosecutor wants to make them look like a liar over. So sometimes our clients will testify. One thing that we always do with our clients, just as a matter of practice, is we prepare them as if they're going to testify. So
Every
part
time.
of our pretrial preparation is we will go through a detailed direct examination as well as mock cross examinations with our clients, so that if there's a reason where they need to testify at trial, they're prepared to do that, and they can make an educated decision, because it's their decision ultimately whether or not they want to testify in their case. So we're going to prepare them to be ready to do that and to make that decision well. The worst thing I've ever seen, and it was when I was a prosecutor, is when a client wasn't expecting to testify. Their attorney had not prepared them to testify at all. It was a very serious case, and the defense attorneys were looking at their client and like, well, now you have to testify.
Oh boy,
And
that's
it wasn't
terrifying.
good. And I saw that play out. Now,
Ugh.
I mean, the person had hired a hitman to kill his friend, and so that person deserved to do time at Leavenworth.
Sure.
So God, God is sovereign. The right thing worked out for me as a prosecutor in that case. But I mean, there was a moment, even as a prosecutor, where I had a degree of empathy for that accused, even though they were guilty of not being prepared to do that. So we always do that. So once the case concludes, then we have a closing argument. So closing argument is a really interesting part of trial. There's a lot of back and forth on it. Caleb has talked about, he thinks opening statement is most important. Cross-examination is a close second. For closing argument, Caleb, share some thoughts, if you want to put it kind of a prosecutor's hat on first, about closing argument, its importance, and what you think, how much you think it matters in this process.
Well, every judge I've ever been in front of has always had the opinion that closing argument is the least important part of trial.
Mm-hmm.
And from their perspective, it's because everyone has already made their mind up by the time they get to close, and they're just ready to go deliberate and get this trial over with. I don't necessarily think that's true. I think there's a lot of very good advocacy that happens in closing argument that can be persuasive. Um, I one of the things that closing argument really does for me is closing argument drives my entire trial preparation.
Right. No, and I'm glad you said it that way, because that's how I look at it. So I will say to people, and I sincerely believe this, that closing argument is the most important part. But it's not that what an attorney stands up and says in closing
Yeah.
argument is the most important thing that happens in the courtroom. That's not what I'm saying. But in your pretrial preparation and everything that happens leading up to closing argument, I how you prepare for a closing argument is the most important thing that happens in a trial. What do I mean? If it's not evidence in the courtroom, if it's not something that is relevant to the case, you can't talk about it in closing argument.
Yeah.
So I look at closing argument like a movie. And what I mean is, think of a cinematic production, right? In order to get that cinematic production, you have to have all of the pieces in place. There are all these moving pieces and parts that go to this final production that happens, that you go to the theater and watch. And I think of closing argument the same way. If I was a director or a producer on a movie, I can't get the final version of the movie unless I have a plan, and I have to know where I'm going in order to arrive at the right place. So I might be shooting all of these different scenes on these different locations with these different actors from different angles. But my whole point is I need all of these different pieces, and I need to be able to take them and fit them together to create a movie that makes sense and flows and is a finished product. So for me, when I get involved in a case, I mean, to be honest, sometimes I'm thinking about what would I say in a closing argument in this case during the investigative stage of a case, before we even know that there's going to be charges, before we know that there's even going to be a trial. If I'm hired on a case, I'll be on my morning run and I'll be thinking about what would I say in closing argument in this case? What are the themes? What's the theory of the case? What argument is going to resonate? But even just as critically as that, it's not just about, your rhetorical flair or flourish. It really helps you frame, what evidence do I need? What testimony do I need to come in during trial to be in front of the court-martial panel members so that I can make a closing argument that can reveal the truth and ensure a just outcome in a case. So yes, an attorney, the best closing argument I ever saw a defense attorney give was a closing argument where they literally stood tied to the podium and they essentially read it word for word, mostly looking down in a somewhat monotone voice. But it was absolutely effective in that case because that's what he had prepared to do. And that was his style. So it wasn't the style. He wasn't a great, orator. He wasn't, Johnny Cochran, and it wasn't flashy, but it was effective. And it just showed the level of preparation that he put into everything, because everything fit together in this closing argument. So,
well, and let me say too, for me, this is the way I used to teach it when I was teaching courses in the JAG school, or I'm sorry, not the JAG school, in the JAG Corps, for prosecutors and defendants. Is I watched a TED Talk by a chess grandmaster who explained how to win a chess game. And the way he explained it, there's really two ways to win. You start at the beginning and you make a better move every time than your opponent makes. Well, that's really, really difficult when you're playing across other really good chess players.
Right.
The other way to win a chess game is you memorize particular end games where I know if I get to this position, I win 100% of the time. And then what you're really shaping is you're shaping your chess game to put yourself in an end game that you win. And that is really how I think about a closing argument. That's my end game. I'm thinking about, if I get to this argument, if I get to this, argument at this point of trial with this evidence, that is going to put my client in the best position possible. And so then that drives every single move we make before that to get to that end game scenario that puts us in the best position. And that's really the value of close.
Okay, so kind of one last time, just to quickly wrap up, we walked from investigation through preferral, Article 32 hearing, referral process, pretrial, docketing, scheduling orders. We talked about all that stuff. We walked through the kind of trial process. So we think of it in terms of, we pick a court-martial panel, we pick a jury, we have opening statement. So we have a government's case, defense case, We get to closing argument. After that, the judge provides a list of instructions that we get to comment on. We get to help frame the instructions. It's presented to the court-martial panel, and then they go into a deliberation room. They discuss the case. They vote by secret written ballot. They come back out. The president of the panel, the senior ranking military member on the panel, makes the call. And if we've done our job, there is an acquittal. It's not guilty, and everybody goes out for ice cream, and we are all set. No, but in all seriousness, that's what it looks like done well. That's what this process looks like, and that is our goal. I mean, if we're going to trial at a court martial, we're going to try to get the best just outcome we possibly can for our clients, and that's the job. So we have spent a little over 90 minutes here talking about the court martial process. Our hope in this is to just give you kind of an inside look from the perspective of a former Army senior prosecutor, former #1 ranked senior defense counsel in the Air Force, for what that's worth. Hopefully this gives you an insight into the court-martial process. And again, if you want to comment on this video, please do ask us questions. Again, this is not legal advice, so don't ask specific questions about your case in comments. The government might have access to that, but you certainly can reach out to us, set up a free strategy session. If you, someone close to you is going through this process, we certainly be happy to answer questions. And our goal as we go through this is to provide some other more detailed videos about different aspects of this process. So if there's a topic that you want us to dive deeper on or something else you want to talk about as far as this process goes, please feel free to comment on those things as well. Thanks for taking the time to listen to this. God bless you all.
Left to men like Davis Younts fighting for these Navy SEALs.
Davis Younts, you are an attorney who has successfully defended naval officers.
Davis Younts has been instrumental in defending.
Davis Younts successfully defended an evangelical Navy lieutenant.